Committee will come to order, and our first order of business is to open the hearing on Senate Bill 448, establishing procedures in the Kansas Code of Procedure for municipal courts related to determination of an accused person's competency to stand trial. And with that, then, a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair, and good morning, committee. You have a bill brief in your packets. Senate Bill 448 is the bill requested in committee earlier this year by Senator Corson. Forget to mention that sometimes, but I'll mention it this time because he's sitting right in front of me, so it triggered the memory. This is the bill that deals with municipal courts and determination of an accused person's competency to stand trial. There's a new section that's provided there on page 1 that would become part of the Kansas Code of Procedure for municipal courts, and it would establish some new procedures for the determination of an accused person's competency to stand trial. It is fairly similar in a lot of ways to the Kansas Code of Criminal Procedure statute, and so I'll mention that here in just a moment. But the provision is pretty straightforward. It says at any time after the defendant has been served with the complaint and before the pronouncement of the sentence, if the municipal judge before whom the complaint is pending finds there is reason to believe that the accused person is incompetent to stand trial, the municipal judge may order an examination to determine the defendant's competency. To facilitate that examination, the court is given 3 options there on page 1 in finding an evaluator or an examiner that could do that task. And then the cost for the examination or evaluation would be paid from municipal court funds or from the general fund of the municipality. The last piece of the new section is that if the examination or evaluation shows the accused person is incompetent to stand trial, the city attorney would then request the district attorney or the county attorney to review that case for the filing of a complaint in the district court. This definition of incompetent to stand trial and the standard there would be the same as the one used in the Kansas Code of Criminal Procedure. And I listed it there in the bill brief. It's the person charged with the crime because of mental illness or defect is unable to understand the nature and purpose of the proceeding against such person or make or assist in making such person's defense. So the same standard would apply under either statute. The case, if it's accepted and filed in the district court, then the municipal court would dismiss their criminal charges and the district court would proceed under criminal code, code of criminal procedure, KSA 22-3302, related to proceedings to determine competency in the district court level. If the case is not accepted by the district attorney, but that determination was already made that the defendant was not competent to stand trial, the municipal court would still dismiss those criminal charges against the defendant, and that would be the end of it. Essentially the same thing that happens under current law, as I understand it. Section 2 then amends a statute the legislature just enacted last year, KSA 19-1936. This is the one that requires the Secretary for Aging and Disability Services to reimburse counties for the cost of keeping certain persons in the custody of a county jail while they're awaiting examination, evaluation, or treatment. The bill simply adds Section 1 to the list of statutes you have there in subsection A, and that means that the Secretary is going to be required to reimburse the county that maintains the county jail where a person is in custody awaiting examination, evaluation, or treatment pursuant to Section 1. So KDADs would be paying for these folks just like they pay for other folks waiting for competency evaluations. And that was a policy choice made by the legislature, and they're asking to add the folks under Section 1 to that same provision. The last thing I'll say is that this would become effective on July 1st, publication in statute book, and I'm happy to take any questions.
Thank you. Committee, any questions? Not seeing any, then thank you. We will invite our first proponent conferee, Ryan Dixon, municipal judge with the City of Overland Park. Please introduce yourself and welcome to committee. It doesn't sound like it.
Hello.
There we go.
Good morning, Madam Chair and members of the committee. My name is Ryan Dixon. I am the municipal court judge for the City of Overland Park, Kansas. I'm here today as a proponent of Senate Bill 448, which would provide a uniform process to courts to follow when dealing with individuals that may be legally incompetent to stand trial. Also here with me today in attendance is Judge Keith Drill from the City of Mission Municipal Court in Johnson County. He is a current board member of the KMJA and the president-elect. And the KMJA also is in support of Senate Bill 448. So I'm assuming that this is a pretty straightforward bill, fairly easy to understand the concept. What I'd like to do is give you a scenario that happens frequently in my court. And I would imagine a scenario like the one that's following would occur in a lot of courts, municipal courts throughout the state. So imagine, if you would, a cold night, a defendant or a potential defendant who is homeless, sleeping on the streets, a drug addiction or an alcohol addiction, and severe mental illness. In Overland Park, he goes into a Quick Trip or a convenience store. He goes to the back, goes into the bathroom, locks the door, and he passes out on the floor. Patrons of the Quick Trip, they try to knock on the door because they've got to use the bathroom or whatever. He's not answering. The manager gets involved, calls the police. The police come out, they get in, and during the time they're trying to get this gentleman out of the bathroom, there's a scuffle, and he punches one of the police officers in the face. So he gets charged and arrested for criminal trespass and battery on a law enforcement officer. He's suffering. He's in a crisis, mental illness, drug addiction, like I said before, and he's homeless. So I see this gentleman on video from the jail the next day, and he's sitting in the chair, and he may be yelling nonsensical things in between obscenities. He may be combative with jail staff. He may be listening to auditory voices in his head. He may have no effect at all. He may not be able to understand and not be able to speak or communicate or understand what the judge is saying or what I'm saying. So it's obvious to me that this gentleman is mentally ill and he's in crisis. He's in custody at the moment. The question is, what can I do about it as a municipal judge? The law does not allow a municipal judge to order a defendant into treatment. I can get an evaluation even without this bill passing. It's not mandatory, according to the bill, that a judge actually get a competency evaluation. But I can do that, and that evaluation would tell me pretty much what I already know in this situation. Again, the problem is, what do I do with the mentally ill defendant to get him help and treatment? I have two options, basically. I can dismiss the case, and I can release the defendant back to the streets for him to walk up the highway and look for another Quick Trip. Or the second option is I can find a way to get him to the district court. If this gentleman gets to the district court, according to KSA 22-3302 and 3, the district court judge has more tools available to help that judge get this defendant treatment. A district court judge can order inpatient treatment, including a state hospital. Outpatient treatment, a district court judge can order that meds be administered, as well as a district court judge may be able to get the case transferred basically to a Chapter 59 case, probate, a care and treatment case. So how do I do that? Senate Bill 448 would allow a municipal court judge voluntarily to order a competency evaluation. Ideally, that competency evaluation would be the same evaluation that's administered in the district court. That's the way we do it currently in Johnson County. We use Johnson County Mental Health to do the evaluation, which is the same evaluation that the district court uses. So whatever, when that evaluation comes back, if there is a determination made that the defendant is incompetent to stand trial according to the evaluation, then the municipal court acts according to this bill. The city prosecutor would have to contact the district attorney or the county attorney at the district court level and ask that the case be transferred to the district court. The district court, the county attorney or the district attorney does not have to accept the case, does not have to transfer that case. But if they do, then the case would be dismissed by the municipal judge and the defendant would continue on through the district court competency evaluation and treatment process. If the district attorney or county attorney does not accept the case, then we're in the same situation that we were before, and the municipal court would have no choice but to dismiss the case. So it may not be the best solution, but it is the best solution that can work under the circumstances that we're in without major changes to other types of law like care and treatment. So I have been informed that that you may be hearing some testimony today that's in opposition to the bill. Overland Park, the city of Overland Park, the KMJ, and I all believe this is a great bill. But if we can make this bill better by listening to and including the concerns, addressing the concerns of those that have concerns, we're happy to do that. Thank you for your consideration today. I respectfully request that the committee advance Senate Bill 448 to the full Senate, and I'm happy to answer any questions that the committee may have.
Thank you. Go ahead and stay at the podium because I don't think we have any other proponent conferees wishing to testify. But if there are any, please say so now. Not seeing any. Committee, we do have proponent written only testimony in your committee documents from Karen Torline, Kansas Municipal Judges Association, Chair Legislative Committee, and from Keith Drill, President-elect, Kansas Municipal Judge Association, from Rashane Hamby, Director of Policy and Research at the ACLU, and Sharon Dix-Groff, City Attorney, City of Wichita. And with that, then, we will open it up for any questions for our proponent conferee. Yes, Senator Corson.
Thank you, Madam Chair. Can you talk a little bit? My understanding is that there is a lawsuit involving the city of Wichita that touches on this issue, which is part of the impetus for this legislation and maybe speaks to the need of it. Can you talk a little bit? I know the lawsuit, my understanding, is still pending, but if you could just talk a little bit to the extent you know about that lawsuit and the issues involved and how it relates to this bill. Thank you.
Well, constitutionally speaking, the Fifth Amendment to the U.S. Constitution, as interpreted by Supreme Court precedent, says that it is a Fifth Amendment right to due process, that nobody is sentenced, basically, if they are incompetent. So as of that precedent coming out in the 50s, judges have had to take into consideration competency issues in a criminal court. So my understanding is, and this is a generalization, and I don't want to misspeak because there is litigation still, but the municipal court in Wichita had made the decision, possibly, or it just happened, but cases were being adjudicated either by plea or going to trial, and the issue of competency was not being addressed. So if I had to guess, and I hate to guess, but it may have been an attempt to get the case to the district court through a de novo appeal. If you don't have any other options, like I said, it may have been a decision that was made consciously to take a plea, to get a trial. If there's a guilty finding, then encourage the parties to have a de novo appeal in district court. That is a backdoor way to get the case, like I said, to a district court.
Thank you. Committee, other questions? Senator Steffen.
Thank you. I'm looking at our fiscal note, and on page 2, it starts talking about the state security program at Larned State Hospital and additional defendants that could be referred under SB 448 would be added to the wait list for the state security program. The average wait time in January 2024 was 440 days. Is this bill going to fix anything? If we're referring into a program that's a year and well over a year before
You're talking that state hospital referral and the wait time. I didn't hear all of your question. I'm sorry.
Yeah. Yes.
Okay.
The average wait time at Larned State Hospital for evaluations is 440 days.
Okay.
So how does this bill fix anything if it sounds like southern border and tell them to come back in 5 years?
Well, we're talking about misdemeanors that are coming out of municipal court. KSA 22, 3302 and 3303 does contemplate treatment for a defendant with a misdemeanor case in the district court. I'm not an expert at the statute, but the way I read the statute is that the first thing that would happen on a misdemeanor case is outpatient evaluation, outpatient treatment. Certain things have to happen. Evaluations need to be done, or recommendations from a treatment provider would have to occur in order for a misdemeanor defendant in a district court case to end up getting an evaluation and or treatment in a state hospital. My off-the-cuff answer, so to speak, would be it's likely not going to happen in a district court setting that a misdemeanor defendant is going to end up in a state hospital because it can be done outpatient treatment or a local inpatient treatment, so to speak. I hope I answered your question. I didn't hear all of the question. I apologize.
Thank you. I have a follow-up question, taking a look at the fiscal note. And you had said a couple of things, and the fiscal note says a couple of things according to KDADS. And you seem to confirm that most municipal charges are at the misdemeanor level, and that a district court for a misdemeanor probably would not make the referral to a state hospital, but the bill would allow the municipal court for a misdemeanor level charge to make the referral to the state hospital. Do I have that right?
If I understand your question correctly, it is possible if this bill were to pass, that if the district attorney were to accept a misdemeanor case, and then that case goes through the district court, KSA 22-3302, 3303 competency evaluation and treatment process, part of the district court process could include a defendant with a misdemeanor going to a state hospital.
Do we have any statistics how often our district courts do that? Or is it primarily for felony charges that our district courts refer to?
Yeah, I think it's primarily felony. Just based on my own experience in past. Misdemeanor charges would probably be sent to an outpatient setting first to get the evaluation and outpatient treatment first. It would be maybe a final option when all other options are exhausted that it go to a state hospital.
So thank you. And looking again at the fiscal note, that with the authority that this bill would provide to our municipal courts to order a defendant to a state hospital, that the fiscal note says a defendant with a misdemeanor charge will wait for state hospital placement for a time that would exceed the amount of a jail sentence. Could you speak to that?
Well, the municipal court would not be ordering a defendant to a state hospital. It would be a district court judge that ultimately could order a defendant to a state hospital, because the municipal court case has been transferred to the district court through this bill. So the district court judge would make the decision on where the defendant would go. And once again, to reiterate, I don't think it's likely that a misdemeanant in a district court case is going to end up in the state hospital. I think the first place that defendant would go would be an outpatient treatment setting. And it wouldn't get to the point of a state hospital. But in answer to your question, yes, a 1-year jail sentence is the maximum a municipal court can order on a misdemeanor, or a district court judge can order on a misdemeanor. So if the average wait time is 400 and some odd days, then the defendant's potential sentence would expire. But if I'm sorry, if I could say something else. The district judge knows all of that information. The district judge would know that there's time limitations, and the district judge might take that into consideration on choosing the treatment setting.
Okay, so maybe I'm misunderstanding the bill. When in section 1, and Mr. Thompson, if you can help out too, in section 1, subsection A2, it says the municipal court may order an evaluation be completed. It's 1A, 2A, an evaluation be completed. So if you're either by an appropriate state, county, or private institution or facility. So if you're awaiting an evaluation at our state hospital, are you a patient at the state hospital while you're awaiting evaluation, or are you living at home, or you're in jail, or where are you while you're waiting for these 440 days?
Madam Chair, I apologize. I misunderstood your question. You're talking about if a municipal court judge were to order an evaluation, the thinking is at the moment that that would occur at a state hospital. Is that the question?
Yes.
That would not occur at a state hospital. I cannot refer a defendant in my case, in my jurisdiction. I can't refer a defendant to a state hospital. So the way it happens, we've been doing this since the middle of 2021. The way it would happen is that the defendant who is in custody in my example, for instance, Todd Schimmel from Johnson County Mental Health, who does the evaluations for the district court, he would visit the defendant at the jail. He would do the evaluation while the defendant is in custody at the jail in Johnson County. The competency evaluation, when it's ordered to when I get it, takes about 5 to 7 days. And it's done locally at the jail.
So, but the bill provides, Jason Thompson can help answer this. The bill provides at section 1A, 2A, that you could, a municipal court, a municipal judge could order an evaluation at a state facility. And we're hearing that at our state facility, it's a 440-day wait. So that could happen if the bill were to become law, correct?
Madam Chair, Jason Thompson, Revisor's Office. I think
or not. Maybe it's
I think the other law that the judge is referring to would prohibit that. Even though this says you can order an evaluation at an appropriate state, county, or private institution or facility, you're still bound by all the other restrictions provided in law about how you get to, say, Larned State Hospital. And I don't think KDADS would accept that person if the judge tried to send them, because they have law saying they can't take that person. I think that might be
that's what the judge was trying to explain.
I don't have the authority to send somebody to a state hospital. So if that needs to be amended and taken out, I can see how that might cause some confusion. That was unintentional. I think language was pulled for efficiency's sake from the state district court statute.
And there is a $3.8 million fiscal note attached to this that has been provided. So do you have any comment on that?
Me?
Yeah.
All I can say is that in 2021, we started basically this process that we're proposing in the bill. In 2021, it was half of a year. We had one competency evaluation in the city of Overland Park, second largest city in the state. We're one of the largest by volume courts in the state as well. 2022 was a full calendar year. We did 3 competency evaluations. 2023 full year, we did 4 competency evaluations. We've always had competency issues in our court, and it's been known to our public defenders and our experienced defense attorneys that we do consider competency, and we will order evaluations when needed. The floodgates did not open. There was not just a rush of defense attorneys coming in asking for competency evaluations. Of the 8 competency evaluations we've done basically in the last 36 months, 6 of those were found incompetent. Those 6 persons that were found incompetent were requested transfers to the district attorney's office. 1 was taken by the Johnson County District Attorney's Office. So for a city of our size, a court of our size, I'm glad that I can say these aren't huge numbers, huge cost, but if there is an expected cost because of an expected flood of competency evaluations, it hasn't happened in our court in the last 36 months.
So if you've been doing the competency evaluations, why do you need the bill?
We have cooperative prosecutors that voluntarily will send the case to the county. We have a district attorney's office that will more or less listen and consider taking the cases. We have judges in Overland Park that will consider ordering an evaluation and trying to get help to get to the case to the district court. That may not be the case. That may not be the situation in every district court, every municipal jurisdiction. I think it's important that the legislature provide a process, if you want to call it a best practices policy, that's voluntary for the judge to follow, that would help cities all over the state grapple with these issues. And there has been a lawsuit filed in Wichita. I fear that a lot of cities were following Wichita's lead on how to deal with these competency issues, which is basically doing nothing. So I think that it's time for the legislature, it's a good opportunity rather for the legislature to show these municipal courts across Kansas that this is a process that can be followed.
Thank you. And then in section 1A 2B at line 22 on page 1, this would allow the municipal judge to, in order to facilitate the examination, the court may appoint a licensed physician who's qualified through training or experience, or a licensed psychologist to examine the defendant and report to the court. Who pays for that licensed physician to prepare the report and conduct the examination?
That'd be the city, according to the bill.
The city would?
And I think that's also language that was pulled from the state statute. But in reality, in our jurisdiction, we use the county mental health department. We use the same evaluator that the district court does.
And that would be kind of in subsection C on page 1 of the bill at line 25. Order an evaluation or appoint an examiner from a list of competency evaluators that the district court uses. And so what's to prohibit in subsection B there that, you know, it's a way to get business to physicians and the court's going to make more competency evaluations in order to help out physician friends. I mean, I'm not saying they would, but I just try to go to worst case scenario. And do you have any thoughts on that?
No, I guess that could happen, but that's a matter for judicial rules of conduct and ethics. Somebody could be prosecuted. So we could come up with a scenario like that with a lot of different legal situations where it's up to the attorney and the judge to not take advantage.
Right. It was just posed as a worst case scenario.
Yeah,
so not
sure,
the
sure.
usual, but just a worst case. So,
Sure.
Well, great. Yes. Any other questions? Senator Corson.
Thank you so much, Madam Chair. I want to go back to just the fiscal note. My understanding from reading this is that if we clarified, or I mean, it sounds like currently you, as you've stated and as the revisor stated, you cannot send someone to the state hospital. And it sounds like if we clarified that and just made, you know, that explicit, maybe more than it already is, it seems like the fiscal note would go away, because the bulk of the fiscal note kind of contemplates, and I think, you know, maybe the person who put this together maybe didn't realize the interplay with the different statutes that are still involved that would actually not allow you to send somebody to Larned. So my understanding is, again, if that was further clarified, are you in?
Testimony.
Thank you.
Are there any neutral conferees wishing to testify? Then we will turn to opponent conferee, Amanda Stanley, City Attorney, City of Topeka. Please introduce yourself and welcome to committee.
Thank you so much, Madam Chairman. I am Amanda Stanley, City Attorney for Topeka. Competency is something the City of Topeka is very familiar with. I wish we only had one case a year that we had to deal with on competency. In 2023, we sent 15 cases in 2023 to our district attorney, and that can be a low year for us. We are a community that, if you read our news, has had struggles with mental health and homelessness, and we regularly see that in our municipal court. That being said, we don't think this bill actually solves the problem. It leaves you right back into the same spot that you started, but with more money, time, and potential expenses and uncertainty that this adds to the process that we think creates bad public policy and a bad law. I think cities are really good at finding ways to fill voids, and we hear that a lot from our citizens of, why can't you deal with this person that breaks into homes, he gets out of jail, he goes, breaks into homes again, and he's got competency issues. We have a really good working relationship with our district attorney that we have worked very hard to build, putting all the players at the table to help deal with those complex individuals that do cause real issues in neighborhoods because they come back and they have mental illness. But currently, statutorily, municipal courts do not have the authority to order competency. We think as a public policy, that's something that should remain, where you do not have authority to order competency evaluations. We are not courts of record, a municipal court. So I just want to walk you through how this would work either way. So our municipal court judge, if you had authority to order competency, would order a competency evaluation. We do at jail dockets. We see the same thing. He asks questions like, who's the president? And when you hear Mickey Mouse, you probably have competency evaluations. And those are just standard things that we deal with in municipal court. So if under this bill, we ordered a competency evaluation, first off, not every community has the robust mental health providers that Johnson County does, where you can turn around a competency evaluation in 5 to 7 days. Statutorily for district courts, you have a maximum of 90 days to get that done. This bill does not set any time limits, which we find slightly concerning, that you could hold someone in jail while you await a competency evaluation for potentially unlimited time under the bill. So you get a competency evaluation back. Let's say the person's found competent. So we try him in municipal court, he's found guilty. A municipal court is not a court of record. So if you have a competency evaluation, constitutionally, you have to provide a court-appointed attorney. In Topeka, we have public defenders on staff, and so we have that ability. But any attorney that is worth their salt is going to appeal that based off the competency to the district court. At the district court, it is a trial de novo. It starts over completely. It's like the municipal court, trial never happened. So you've already paid for a competency once. You're going to pay for a competency again at the district court. That is just a reality of how the process is going to end up playing out. So that's if they're found competent. You still end up paying for it twice. Might be different levels of government that are paying for it. One time it's a city and one time it's a county, but it's all taxpayer funds that are paying for it twice. Let's go the other route. Let's say they're found incompetent. You have no jurisdiction, even under this bill. If they're found incompetent, you have to dismiss the case if the district attorney won't take it. Under this bill, it says it automatically transfers. We have some very real questions about how that would work. We assume our officers would still have to file a charging affidavit. Currently, the process we use with our district attorney is if we have competency concerns without a competency evaluation, we dismiss the case, officer files the charging affidavit, the district attorney understands we're sending it because of competency issues, decides if there's facts, and charges the case. Under this bill, it says it goes to the district attorney. He gets to decide whether or not to charge it or not. Only if it's filed is the municipal court case dismissed. So there for a while, you have somebody being charged in 2 different courts for the same offense at the same time. So we think constitutionally, you should probably have the municipal court dismiss it before it is charged in district court. And then it says you go straight into the competency statutes. Well, then the district attorney is going to have to order another competency evaluation, because I don't understand how you can rely on a competency evaluation from a totally different jurisdiction to upheld a district court case where you have competency concerns. These are 2 different jurisdictions. Municipal court is not the same jurisdiction as the district attorney. You're filing under municipal ordinances the first time. The second time you're filing is misdemeanors under state law. So you're in a different jurisdiction. So then you're paying for a second competency evaluation. Let's say someone sat in jail waiting a competency evaluation the first time. Even if it's only 5 to 7 days, or in our rural counties, it probably could be up to 90 days. Then they're going to sit in jail again while the district attorney gets a second competency evaluation, potentially up to 90 days again. And so then you're sitting in jail, potentially, worst case scenario, up to 180 days for something that has a standard jail time of 5 days. that probably as a public policy doesn't make sense. Additionally, municipal courts have no ability to cure competency, and we don't think they should. They're not courts of record. You appeal and it's a de novo. So if you can't cure competency, and if the district attorney does not accept the case, you're back in the same position under the bill that current law is. You dismiss the case because you have no jurisdiction. So while we understand this desire to make some kind of uniform ability for municipal court judges to follow competency, I also understand that not all cities have the working relationship we do with our district attorney, where it's interactive dialogue, and our police department, and everybody works together to find a common solution because we all serve the same constituents. I understand that, but I don't think this bill does anything except add more money, add more time, and complicate the process. Because once you have a state law that says how you should do something, it's never really voluntary. Defense attorneys can petition for competency evaluations like they should be able to. So you're going to have to figure out how to deal with this. That being said, competency is something that as a city attorney, I feel like I know really well because we keep dealing with it over and over. So we do understand there's a problem in the state. Whether or not the root of that is really that we can't order competency evaluations, or if the root of it is we need more investment in mental health, we need more investment in the issues that are at the root cause, I don't know. I do think this bill is not ready to be advanced. At a minimum, I would suggest a judicial council, something that has all the players at the table. District attorneys are going to be affected by this bill if it transfers over, and if the pieces work and does it statutorily and jurisdictionally work, they need to be at the table. Your municipal court judges need to be at the table, but your prosecutors do too, because once the municipal court judges ordered competency and the prosecutor is now the one that deals with the case after that, they're the one sending it to the district attorney. Our police departments are the one filing the correct paperwork and correct charges. And then my prosecutors are the ones that have to do all of the appeals de novo if it continues to go through municipal court. So I think you need all of the various pieces. You need the police department, you need the prosecutors, you need the municipal court judges, but you need the district court judges. And then you need the overarching city attorney that has to actually watch all of this and look at budgets and figure out how much competencies evaluations are going to cost as we order those. Talking to city attorneys over the last year and a half, I have heard ranges from $600 a competency evaluation down to some counties that do them for free. So it's all over the place. And I would argue it's probably free for the city. It's not free for the county if they're doing it for free. So we just think there are a lot of questions that this bill raises to ultimately be back in the same spot where you are voluntarily sending it to the district attorney, who can choose to charge it or not, which is the same system. And if he doesn't, you have to dismiss the case, which is currently our system. So we do not feel like this bill actually solves the root of the problem. And I am happy to stand for any questions.
Thank you. Are there other opponent conferees wishing to testify? Not seeing any, then we can open it up for any questions from the committee. Senator Corson.
Thank you, Madam Chair. I mean, it sounds like from your testimony that you've kind of cobbled together a process that works really well for the city of Topeka. But my concern is city of Topeka is a large city. Shawnee County is one of our larger counties. My concern is, going back to the Wichita litigation and other things, are what is going on throughout the state. And I do worry about folks who are potentially having their rights violated by being tried or convicted while they're incompetent to stand trial. And I worry about the exposure to litigation that we could have if this is, a more widespread issue. So I guess I'm sympathetic to your position that you have a process that works well for you, but I'm not sure that is really something we can replicate or scale across the state, because again, you're a larger city, part of a larger county, and I just worry about what is going on in our smaller and more rural jurisdictions. And that's kind of why I'm a believer in this legislation, because there are oftentimes where the state does want to set uniform policies and procedures across the state. So cities, you're an excellent city attorney and you've cobbled together a process that works, but not all cities are going to be able to have those resources and somebody of your capabilities to shepherd through that process. Thank you.
Okay, I'm not sure there's a question there, but are there other questions or a question for the conferee? I have a question. You're aware of the City of Wichita lawsuit, and given that, does that change your position or the points or the objections that you shared?
It does not, because I don't think that bill actually fixes the concern that Senator Corson just raised. So, as a city attorney, county attorney, your job is to care about liability under 1983 claims. I pay a lot of attention to cases like the City of Wichita. And my job is to say, if we don't think someone's competent, you can't try them, because that is a constitutional violation. But this bill doesn't mandate that a judge order competency evaluations. It gives a process if they would like to, but it doesn't mandate it. So if you have a city or a county that is not paying attention to those 1983, which are very real damages, so you really should, it's not going to stop this, because they're not going to step in and say, why are we not doing competency evaluations? But even if you follow this process, you're still going to have the pushback that leads to cities trying people that they think might not be competent, because there is nothing in this that mandates a DA take the case. Like the City of Wichita right now, any city in Kansas, can and should be dismissing cases that they don't think someone's competent, and they can and should be referring them to the DA, which is what this bill says. But they don't have to take them. So even under this bill, if your DA takes 0 of those cases, you are stuck in a position where you were at before, saying, I don't know what to do with these people, because we just keep dismissing the case and dismissing the case and dismissing the case. And it's those dismissals and the public outcry that lead people to make decisions that they probably shouldn't make. And none of that's removed under this bill, because it's all still voluntary on the DA's part. It's all still voluntary on the municipal court judges to order them. The only thing that's not voluntary is if you do order it, you have to dismiss, which you already have to do because you have no jurisdiction over someone who is incompetent. And if you aren't, you are opening yourself up to liability. And if cities and counties want to do that, as much as I hate saying it, sometimes you have to learn from what you do wrong too. And 1983 is not something you should be messing around with.
In 1983, you're not referring to the year 1983. It's a U.S. Code Section 1983 claim, where if your constitutional rights are being violated by a state actor.
And cities and counties are considered persons under 1983 that can be found personally liable for 1983 claims, as well as your municipal court judge could be found liable and sued personally for that. So anytime you have a constitutional right violation, that opens yourself up, and be a city attorney and you get to learn the constitutional law, because everything we do has potential impacts.
So I have one last question. You've said a lot about the bill doesn't mandate this, it doesn't mandate that. If the bill did mandate the competency evaluation be ordered and mandate that the district attorney take the case, would your position change?
I think that would be very hard to have looked at the facts. But let's say hypothetically you say, yes, we're going to mandate the DA take the case. Potentially, yes, I think we're still going to have to figure out the costs. In a city like mine that has substantially more than Overland Park, you would want something in statute where you could have some cost control or something. So if we only have one provider, we're not paying $600 a piece for these, especially because you could, every time someone gets picked up on a misdemeanor, that's a new case and a new competency evaluation. You can't use their competency evaluation in the last case, because each case you have to know in that moment, are they competent? So it potentially could spiral. We're a different socioeconomic and mental health area than Overland Park. I would imagine Western Kansas, all different parts of our state are different. And I would want to know more data on how much that's going to cost and how many mental health providers we actually have that could do these within the timeframes provided.
Thank you. And if there are one last question, then we've got to move on.
Thank you, Madam Chair. I just want to be sure I understand the city of Topeka's position. Is it that we should not legislate at all in this area, and we should just continue to let all of our different cities kind of come up with a process and procedure, or are there changes or amendments or suggestions that you would make to this legislation that you think could get you to maybe a place where you would feel more comfortable supporting it? Or is it, shouldn't legislate here, period? Thank you.
I think it's neither. I think that this is a constant topic that we keep talking about. And when you have those, that's when it is best for judicial council to figure out what is the right piece of legislation. I don't think this is the right piece of legislation. And we have talked a lot about how you would amend it. And there are so many moving places between us and the district court that I would want the district attorneys at the table to try to figure out what those moving pieces are. It's possible that we could figure out how to amend this into a form that we would support. I'm just not currently seeing how we could do that, but we're always open to talking about it and figuring out ways to find solutions.
Thank you. And with that, committee, then I want to thank you for your testimony today and coming to committee. Appreciate that. And we will then close the hearing on Senate Bill 448. And we will open the hearing on Senate Bill 381, authorizing the Board of County Commissioners of any county that is not the most populous county in a multi-county judicial district to appoint a coroner. And with that, then, the bill brief from the reviser. Thank you.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. This is a circumstance where the short title you just read pretty much sums up the bill, so I guess I did a good job of writing that. This is a bill that amends one section of law. It's current law KSA 22A-226, one that I was not familiar with before this bill, that establishes the Office of District Coroner in each judicial district of the state. The current law there in subsection B provides that the local medical society or societies in each judicial district can nominate candidates for that office of district coroner. They submit the names to either the county commissioners of the single county judicial district, or in those multi-county judicial districts, which we have a few of, they submit those names to the county commissioners of the county with the largest population. And so in those multi-county judicial districts, the county commissioners of the most populous county choose an appointee for the district coroner, and they serve the whole district. What the bill does is add a new subsection B2, which would allow a county that is not the most populous county in one of those multi-county judicial districts to appoint their own coroner that would serve as district coroner for their county. So you'd have a district coroner potentially for some of the counties and a district coroner for that particular county if the county commissioners choose to enact or choose to use this option. The appointee in that individual county would be nominated potentially by a local society, or it could just be some qualified person. They would be confined to all the same restrictions as the other district coroners in terms of office, qualifications, requirements, duties, etc. And the person chosen by that individual county would be paid by that county rather than by the other counties. I think that pretty well covers it, and I'll stand for questions.
Thank you. Committee, any questions? Not seeing any, then we will invite proponent conferee Sheriff David Groves, Cherokee County, Kansas Sheriff's Association. Please introduce yourself and welcome to committee. Make sure it's on.
There we go.
Yes,
All right.
Thank you.
Thank you, Madam Chair, committee members. As mentioned, my name is David Groves. I'm the sheriff in Cherokee County, Kansas, and today I come on behalf of the Kansas Sheriff's Association in our support of Senate Bill 381. As mentioned, current law allows the Board of County Commissioners in the most populous county of a judicial district to select a coroner to serve all counties within that judicial district. And the cost associated with that is borne by all counties within that judicial district. Throughout our state, only 7 counties are single county judicial districts, with all the remaining judicial districts ranging from anywhere from 2 to 7 counties. The passage of Senate Bill 381 would not change the qualifications, duties, terms of office, nor would it require a less populated county who is currently satisfied with the services being provided to do anything different than what they currently are. However, passage of Senate Bill 381 would allow a less populated county who wishes to select and benefit from the services of their own county coroner to do so at their own cost. We believe that by empowering the Board of County Commissioners to select their own coroner, they then have a better ability to serve the citizens of the respective counties by ensuring that the most qualified person is appointed and provides the commissioners and the county an avenue of accountability should the services being provided not meet the community needs or professional expectations. The Kansas Sheriff Association supports the proposed changes to 228226 because it allows the counties who wish to do so to bring the important position of county coroner to the most local form of government. And again, the Kansas Sheriff Association would encourage passage of this bill, and I stand for any questions.
Thank you. Committee, any questions? Yes, Senator Baumgardner.
Yes, ma'am.
Thank you so much for being here today.
Thank you.
Is it possible for a coroner to be retained by more than one county?
Yes, so current statute allows for a district coroner to serve multiple districts.
Okay, thank you very much.
Yes,
I
ma'am.
appreciate that.
Thank you. Any other questions? Not seeing any, then thank you for your testimony today and appearing in person in committee. We appreciate you coming up.
Thank you very much.
Absolutely. Well, with that committee, then we will close the hearing on Senate Bill 381. And we will also then conclude our business for today, and the meeting will be adjourned.